Hi everyone, welcome back to my channel Kanun Sarvopari and welcome back to another study vlog of my life. So in this study vlog, I basically did the remaining subclauses of Article 19 of the Indian Constitution with Pomodoro technique. If you have not watched my previous video, then make sure to watch it because I explained in detail what Pomodoro method is and how it is helping me in my studies. And if you want to try it as well, watch my previous video as well. So I had basically done Article 19 Clause 1 Subclause A in my previous video, like the previous day. This day I actually did the remaining subclauses of Article 19 and a bit of introduction related to Article 20 of the Indian Constitution. So basically Article 19 grants several freedoms to the citizens of India. For example, freedom of speech and expression, freedom to form associations, unions and cooperative societies, freedom to assemble without arms, freedom to travel anywhere in the country, freedom to reside anywhere in the country, and freedom to have any business, trade, occupation. There was one more freedom given in Article 19 Clause 1 Subclause F, that was right to property, but it was removed in 1978 via the 44th Constitutional Amendment. If I tell you the basic reason why it was done, so basically there was a conflict going on between DPSPs, that is Directive Principle of State Policy, and Article 19(1)(f, that was right to property. So basically the Constitution has directed the government in India to focus on welfare of poor, welfare of the people in terms of economy, in terms of social spheres, and also in terms of political spheres and educational spheres. So the government, in order to provide economical aid to the people, needed land, and for that right to property was hindered. Therefore the Constitution was amended several times to remove Article 19(1)(f and also Article 31 of the Indian Constitution. That led to a major case called Keswananda Bharati case in 1970s. This case was a landmark case in deciding the basic structural doctrine in the Indian Constitution. So it was basically held that no doubt the government can amend any part of the Constitution of India, but it cannot amend the basic structural doctrine in the Indian Constitution. And this basic structural doctrine would be decided by Supreme Court from case to case. It at that time included fundamental rights, principles of equality, freedom, sovereignty, integrity of India, and it was held that right to property would not come under the basic structural doctrine within the Indian Constitution, because providing social welfare to the people is also the task of the government. So basically right to property was shifted from a fundamental right to a constitutional right, or we can say it was shifted to a legal right. So basically it is given under Article 300A now in the Constitution. So it is more like a legal right rather than a fundamental right. It is not a fundamental right now. So basically there were several case laws that we have discussed in the previous video. For example, Article 19(1)(a) says about freedom of speech and expression. Firstly, this freedom of speech also includes freedom of silence. That is basically guaranteed in the case law called Bijoy Emmanuel versus State of Kerala. That is also called National Anthem case of 1986. Now comes the topic of freedom of press. So freedom of speech and expression also embodies a fundamental right called freedom of press. That means that there should be no restriction on the spread of information via any means, called magazines or newspapers or anything. There are 4 major case laws related to this topic which I have done. Those were Brij Bhushan versus State of Delhi 1950, Romesh Thapar versus State of Madras 1950, Sakal Papers versus Union of India 1960s, R. Rajgopal versus State of Tamil Nadu, that is also called Auto Shankar case of 1994. Now, freedom of speech and expression also includes the commercial advertisements. That is basically held in Tata Press versus MTNL case of 1995. Now, if we move to another subclauses of Article 19, like Article 19, Clause 1, Subclause B, that says that guarantees freedom to assemble without arms. This fundamental right also says that right to strike is not a fundamental right. This principle that right to strike is not a fundamental right is basically embodied in the case called T.K. Rangarajan versus Government of Tamil Nadu 2003. This case basically overlined the importance of this fundamental right to assemble without arms. It's the Supreme Court in this case held that right to strike cannot be an absolute fundamental right. This is because such strikes can disrupt public services and harm the public welfare, which is a higher priority. The next subclause, that is Article 19, Clause 1, Subclause C, says that the citizens of India have the fundamental right of freedom to form unions, association or cooperative societies. So basically the part of cooperative societies was added via the 97th Constitutional Amendment Act in the Indian Constitution. It was not already there when the Constitution was made. But this freedom also comes with some reasonable restrictions. That is, the unions, association or cooperative society should not hinder the principles of sovereignty and integrity of the country, public order or morality. Like if we study the fundamental rights concept as a whole, then we can say that with great powers come great responsibilities. So yeah, every right in this Constitution of India comes with several reasonable restrictions, which also imposes several responsibilities upon the citizens that they need to follow while enjoying these rights. The next subclause, that is Article 19, Clause 1, Subclause D and E, give the freedom of movement and residence. But both these freedoms under Subclause D and E are subjected to reasonable restrictions. So basically there are 2 grounds for reasonable restriction. Number 1, interest of general public, and number 2, interest of any scheduled tribe. So basically we can see that there are several restrictions upon the purchasing of land in northeastern states, for example, and there was also Article 370 that was subsequently removed in 2019, but before that it also came under this provision because it was basically believed that normal citizens of India from the other states should not go to such areas and purchase land or reside there to basically preserve the community of that area. This is basically happening today as well in the northeastern states to preserve the communities there. Next is basically freedom of profession, occupation, trade or business, but it is also subjected to reasonable restrictions like interest of general public or state prescribed qualifications. For example, if somebody wants to be a doctor, then obviously he needs to have certain requirements which are basically state prescribed qualifications. For example, he needs to have an MBBS degree, he needs to have a certain degree, certain experience or certain expertise. Without that, he cannot open a clinic or practice being a surgeon or a doctor. So such qualifications are required for any profession, occupation, or business or trade. For example, like there are certain laws related to trade and business as well. And also there is a reasonable restriction that the state-run trade, business, or industry cannot be done by normal citizens unless and until it is approved by the state, completely or partially. So basically that was all for this Article 19 of the Indian Constitution. After this I did Article 20, a bit of Article 20, the introduction part. So basically Article 20 gives protection in respect of conviction for offences. So basically there is a difference between the word conviction and prosecution. The word prosecution means that there would be a trial for the accused person, and there can be two consequences of prosecution, that could be conviction or acquittal. Prosecution can result in these two outcomes. So basically conviction means that a person has been proven guilty, and acquittal means that a person has not been proven guilty and he has been acquitted, like he has been released, or like he has not been punished for something that he was accused of. So basically Article 20 gives three kinds of protection, that is protection from ex post facto laws, protection from double jeopardy, and protection from self-incrimination. So that was all I did for today. Make sure to like my video if you really love it, and thank you for watching my video. See you in my next vlog. Bye bye, take care.